is now in session.
Good afternoon to the attorneys. We want to welcome you to the Tennessee Court of Appeals. Your panel today will consist of Judge Frison, Judge Davis, and myself, Judge McClarty. During these proceedings, we will proceed as if we were actually in court, except you will not need to stand when you make your presentation. You've probably already been told, but just in case, I'll remind you, if there's any technical difficulties that arise during these proceedings, please let us know immediately so they may be addressed. Okay. If there's no further matter, Mr. Clerk, are there any preliminary matters?
No, Your Honor.
Then will you please call the case?
Kim Renae Nelson versus Loring E. Justice.
Thank you. For the appellant, are you prepared to proceed?
I am, Your Honor. Thank you. Good afternoon.
Go ahead.
Sorry, I don't mean to cut you off. Good afternoon, and may it please the court. Lynn Guerrero for the appellant. I would like to reserve 5 minutes for rebuttal, please.
Yes. Mm-hmm.
This case has to do with the trial court's award of fees to the appellee after this court awarded appellate attorney's fees to her in a related appeal. Appellee's counsel had 2 separate statements for services. She recorded having done simple tasks for incredible amounts of time. She recorded time for tasks that were simply not done. She billed for duplicative entries and sought and received an award of almost $15,000 for fees that were not incurred on appeal and were outside of the scope of the opinion in the related appeal. However, the trial court clerk's refusal to transmit a record to this court and the court trial's denial of a fair and accurate record for this court to review have become the most important issues in this appeal. After the record was transmitted to this court by the trial court clerk for a second time, hundreds of pages were still missing from the record, and the appellant filed motions in this court to supplement the record. For instance, none of the 22 exhibits offered into evidence were included in the appellate record. Appellee responded to the appellant's motions in this court and did not object to the supplementation of the record. The issue was remanded by this court to the trial court to determine what supplementation needed to occur under Rule 24. However, the trial court, via an order wholly prepared by appellee and never served on the appellant, denied supplementation with no meaningful findings or discussion. Instead, the secret order makes baseless factual findings without evidentiary support and without jurisdiction, like finding without jurisdiction that this appeal is frivolous. The order does not have a certificate of service, and appellee admits this in her brief on page 24. This outright denial of supplementation was without authority under Rule 24A of the appellate rules. Rule 24A of the appellate rules states, the record on appeal shall consist of the original of any exhibits filed in the trial court. Rule 24 mandates the original of any exhibits filed in the trial court to be included in the record on appeal, and the trial court refused to abide by this requirement. The word shall in Rule 24A makes the transmittal of the exhibits in the trial court non-negotiable. The trial court had no discretion to keep the exhibits from this court given the rule's language.
Counsel, excuse me, could you explain to me how this connects with the issue on appeal regarding the attorney fees?
It's stated, it's enumerated in my questions presented for review. And the trial court essentially, by denying supplementation of the record of the very exhibits offered into evidence at the evidentiary hearing, denies the appellant from a fair and legitimate appeal, respectfully, denies this court to the ability to conduct appellate review on the merits. Really, none of the exhibits are here. This court has no way of reviewing the whole record, a fair and accurate record, because the exhibits just aren't here. There are none. given the trial court's denial. Cherry pick the exhibits for appeal. A trial court could always manipulate an appellate record to insulate its rulings from reversal and deny litigants a fair appeal. Given the trial court did that here with the ex parte order, the trial court undermined the very purpose and function of this court. It denied this court the ability to conduct a legitimate appellate review on the merits. Parties have a right to an appeal, and a trial court cannot take that away. The trial courts, respectfully attempted sabotage of appellant's appeal and denying appellant the very basic and fundamental documents required to comprise a record on appeal in a secret ex parte order violates appellant's due process, and this is reversible error. Now, on to the merits, the trial court came to an illogical result and abused its discretion given the evidence that was provided. Appellee sought fees for work in the trial court after the underlying appeal. She sought hours and hours worth of fees for reading one paragraph documents that even appellee's expert witness stated would only take 5 minutes. She sought hours and hours worth of fees for drafting few pages of content. She sought fees for work that could not have been done on the dates that Ms. Peterson's statement claims the work was done. And Ms. Peterson kept 2 sets of billing records that were not discovered until the evidentiary hearing, was almost over. Claims such as the dates may be wrong, but I really did it, just are not good enough. The appellee here had the burden of proof to prove reasonableness of these fees and just did not do that. Conclusory allegations as to the reasonableness fall short of the necessity that due process requires at a minimum that a party seeking to be compensated provide competent evidence. And that's cited in my brief, the opening brief in the Montesa case, Montesa. Like I said, it was the appellee's burden to prove the billing was reasonable to justify an award, and the appellee failed to do that here. For example, here, Ms. Peterson billed for work over 4 days for drafting a 5-page document in July 2019. Ms. Peterson also billed appellee on October the 11th, 2017, for 7.2 hours of work at $300 per hour for drafting 3.75 pages of content. 3 3/4 pages was over 7.2 hours, or for 7.2 hours. I cite Cloke, K-L-O-C-K-E versus University of Tennessee at Arlington, Texas at Arlington, in my opening brief. Here, as in the Cloke case, the appellee sought fees and recovered for, quote, matters that should not have been billed, such as becoming familiar with the local rules. Appellee here sought and received an award for attorney's fees incurred in the underlying appeal for loading a van. Additionally, the trial court awarded appellee approximately $15,000 worth of fees that were not incurred on appeal. And that math is cited in the appellant's reply brief at pages 10 and 11. Also, I want to bring to the court's attention the case I cite on page 35 of the opening brief, Alexander versus Inman. Alexander versus Inman holds that Tennessee courts have held that unreasonably duplicative, unnecessary, or excessive fees should never be considered in determining a reasonable attorney's fee. And that's on pages 36 and 37 of my opening brief. Alexander versus Inman is probably the best case to go to for to deny an attorney fee award given the cases it cites within the opinion and the holding itself. For instance, Freeman versus Crown City Mining Incorporated states that hours are unreasonable when they are excessive in relation to the work done, are duplicative or redundant, or simply unnecessary. And the appellant has established that time and time again in his opening brief and in his reply brief. Also, I do want to point out that nowhere in the appellee's brief does she meaningfully challenge the issues presented for appeal. The first issue that's presented for appeal that isn't meaningfully challenged is the trial court acted without authority to deny the inclusion of the exhibits to the evidentiary hearing to be included in the appellate record. And the second one would be the trial court committed reversible error by awarding the appellee attorney's fees for work that was not incurred on appeal in the underlying appeal. To respond, appellee instead, the brief states she leaves that up to the court whether she was awarded fees not incurred on appeal and outside of the scope of this court's opinion in the related appeal. And that's on appellee's, in appellee's brief on page 16. Appellee cannot simply employ this court to come up with her argument for her to award fees. And that's discussed in detail in appellant's reply brief.
Thank you very much. You have your rebuttal for the appellee. Yes, ma'am.
May it please the court, my name is Cecilia Peterson. I represent the appellee in this case. I may refer myself as appellee's counsel from time to time in an effort basically to distance myself from some of the things that are said about me in their brief. And thankfully they haven't called me a fraud in the video, but they did it 21 times in their brief, and they did it a lot in the trial court. First, let me address this two separate statements business. What happened was I printed a statement and realized there was an error, corrected that one error. It was 2 hours that I had put on one day that should have been on another day. So I deducted it from the day I did not perform the services and added it to the date that I did. That's the only change that was made. It wasn't cooking the books or two separate statements. I freely and ashamedly admit the numerous clerical errors, and my counsel in the trial level who helped me with this hearing said, you know, Cecilia, you really ought to have a paragraph in there that says there may be clerical errors. And that's especially true when I'm doing the typing. And I explained at length in my brief and did in the trial how the errors in dates occurred. And it sounds silly to call it self-populating, but that's exactly what it did. The computer program that I was using before required you to manually enter the date that the work was performed, the services performed, and the time required. The next one just popped up a date. It would be the next date or the same date. So it might look like I have 4 entries on the same day, and I tried to go through and fix it. There's the claim made that I didn't read my statement for services, and that's just wrong. If I hadn't read my statement for services, I wouldn't have taken that 2 hours off the date that I didn't perform the services and put it on the date that I did. It's clear I read the statement. The amount of incredible work that was required in this appeal is the reason for that outlandish judgment. And I do not dispute that it's an outlandish amount. And your honors were there for this travesty that occurred in Nelson 1, I call it, where they filed a 262-page brief with 731 pages of appendices, and then they complained over and over and over again about the record on appeal. This court ordered us in that case, as it did the appellant in this case, to take it back to the trial court and straighten it out. And it wasn't on the trial court, and it wasn't on your court to fix that record. Well, after that, I received zero cooperation in correcting this record that had to come up here, and it was boxes and boxes and boxes. I spent 3 weeks, as I testified, in Roane County Juvenile Court with my secretary, so there was nobody at the office, correcting this record, putting it all in chronological order, making a master index of it, and getting it taken up there. And yes, I did bill for loading a van because we had a deadline to get it up to your honors before the hearing. And Mr. Justice wasn't there to help with any of this. Not 1 minute did he spend correcting this record that he bitterly complained about. And his associate, Mr. Rickman, was in another office doing his thing while my secretary and I and 3 or 4 of the juvenile court clerk employees tried to straighten this record out. It was file cabinets full of misfiled, misdated, disorganized array, misarray, 52 card pickup. So, you know, I did the work and I wrote the brief and I tried to slog through their briefs and to respond to their many motions. And I guess what I'm hearing them say, and I'll begin with the end game. What is their end game here? Is it to say that when I did all of this work and prevailed on every issue for Ms. Nelson, such that this court ordered she be entitled to her attorney's fees, and I made clerical errors in my statement, does that mean I'm not supposed to get anything for all of that work? I took the stand. I told the judge, I'm not trying to trick anybody. I'm not trying to double bill anybody. I'm not trying to do anything except respond to Ms. Guerrero's questions and any questions the court has so that the court would be comfortable with the award that it gave. And it did give me an award. So I took off about $9,000 worth of things that could be considered duplicative. And in the hearing, took off other things. I don't want to make it look like I'm double billing. And the reason for some of those double billing entries, Your Honor, is that Mr. Justice's office never would send me any pleadings that were filed. And this is before true filing. I didn't automatically get a copy of it. They're supposed to send me a copy of it, and I didn't. So I'd go into the office every morning and look at public case history and see what had been filed, then possibly even run get it. And then I'd receive it 2 days later. And when I got the hard copy from the court, I would send it to my client. So yeah, there was some duplication there. I read the same half-page orders twice and so forth and so on. And it's a complete distortion of the truth to say that monumental amounts of time were spent doing simple tasks. If I'm drafting something that's 3.5 pages long, but it involves researching what is the appellant's responsibility for providing a transcript of the evidence that is not misleading and calling it the official transcript when it was not, in fact, the official transcript, that's research. And then I had to make phone calls to the court reporter, and then I had to make phone calls back to Mr. Vallone. It wasn't just a 3.5 page pleading. It's like saying it takes five minutes to read a paragraph. That is true. But then you have to pull the file. And in the many banker's boxes of stuff you've got in this file, you've got to find out what it relates to and what it might mean for your case, and then communicate that to your client. And basically the counsel that I was also representing, because their attorney's fees also depended on prevailing in the Court of Appeals. So there was a lot riding on this. So what is the point of this? I guess it's to embarrass me. Surely they don't think I'm not going to get any attorney's fees with the things that they put in their pleadings and the personal attacks. And it makes me understand why, when reading the 5,573 page transcript to prepare for the appeal, Judge Ash took the time, and they mocked him in their brief. They said he cried about his reputation. He did stop and say, I want to put this on the record. I want to clear this up. I've been called names. I've been called dishonest. I've been called biased. I've been called Yosemite Sam, and my grandkids may read this someday. And I want to put it on the record that I am an honest, hardworking judge and have been for many years. And so I kind of feel the same way, Your Honor. I'm not deceitful. I'm not incompetent. I like that one because I beat him. I'm not fraudulent. I'm not dishonest. I did the work. There were errors in my statement. We corrected those errors in the trial court. Many of the entries in their brief shouldn't be on appeal because they've already been dealt with by the trial court. They were not awarded. Either I took them off or the judge took them off with my complete blessing and encouragement, because I don't want to be compensated, and I don't expect to be compensated. This is basically a hypothetical discussion as if they were going to pay it for work that I didn't perform. It took 3 years, now 4 years out of my life to assist this lady in this appeal. And, you know, while they have the right and ability to point out errors and get those corrected, we've done that, you know, and I can only think that this must be an effort to punish Ms. Nelson yet again for refusing to marry Mr. Justice back when she got pregnant with this child 14 years ago. They've been in litigation for 14 years, and this is just part of it. And it continues to go on. If your honors have any questions, that's all I have to say. I stand on my brief as far as the timeliness of the motion to alter or amend. I don't think it was timely filed. It wasn't properly fax filed. It wasn't noted by the clerk's office that the time that the clerk received it, because it's not supposed to be on their fax machine. They have Greenwich Mean Time on their fax machine. We can't depend on theirs. It has to be the clerk's fax machine. And their fax machine does not stamp file at the top or have a receipt thing at the top of the page that shows when they received it. So it's received when they come into the office and get it, period. So I don't think it was timely. This business about the ex parte secret order, that's where Mr. Justice did not call the court, did not show up for the hearing, and the court on its own motion, nothing I did, and she's got the transcript, so she knows this is true, nothing I did encouraged this court to rule on the motion to supplement. Now you'll note that in their brief on every single page for 30 pages, they talk about this exhibit, that exhibit, this exhibit, that exhibit, and I don't complain about it in my brief because it is what it is. Either the court, they'll take it to the Supreme Court, and if the Supreme Court sends it back, then we'll have the exhibits when we come back here and do this a year or two from now. But the point is, they've had a lot of opportunities. It's not a secret ex parte order. We had a hearing. He just didn't show up, and he didn't call the court. So my personal opinion is the judge was well-founded in thinking he doesn't care about this litigation when he didn't show up. And that's when he addressed the motion to supplement the record and denied it. And I don't think he's required to give his reasons. He gave some reasons. They're not happy with it, but you know, it is what it is. This is the mess they made, and this court, nor I'm not going to do it again, should have to fix it for them. Thank you.
Thank you. You have your rebuttal? Yes, ma'am.
Thank you. Just to start, the trial court at hearing never addressed this motion to supplement the record. Even if it had, I am counsel of record for this appeal. It was my motion. I was never given notice of a hearing. I was never given notice by the trial court clerk. Was never given notice by the trial court or his office. I was never given notice of that. So, I mean, that's due, you know, that's kind of the foundation of due process right there. Notice, an opportunity to be heard, and we got neither on that. So, anyway, moving on though, this court does have jurisdiction. Just very quickly, the order on which this appeal lies was entered April 6th of 2020. The motion to alter amend was filed under the rule of civil procedure 5A under the fax filing rule before midnight on May the 6th, 2020. The trial court clerk, having informed me she did not know the rule about the fax filing, stamped it May the 7th incorrectly. I moved the trial court to correct the trial court record to reflect the correct date of the filing. Trial court granted that motion, and it's corrected. So the appeal is timely. The motion to alter amend was timely, and jurisdiction is with this court. Now, appellee is not entitled to an award of attorney's fees given the circumstances here, and given Ms. Peterson's billing that was submitted for an award of fees. And if this court will look at the Alexander versus Inman case, the Alexander versus Inman case cites two two cases that support this as well. If you see the Perlberger versus Perlberger case, that holds excessive duplication of work is grounds for denying a requested fee award in a divorce case. And if you'll look as well in the Inman case, they cite owner operator versus Super Value Incorporated, which holds incomplete or imprecise billing records prevent the court from exercising meaningful review and are grounds for reducing a fee award. Now, appellee billed 7.2 hours, or Ms. Peterson billed 7.2 hours to draft a 3 3/4 pages of text on October the 11th, 2017, like I said before. To explain this incredible entry, appellee argues, and she seemed to argue here today, for the first time that there were thousands of pages of testimony and that there was a flurry of activity associated with this entry. And that's on appellee's brief at page 14. However, this is not what was billed. Reading the thousands of pages of testimony was billed in separate entries on Ms. Peterson's statement for services. Ms. Peterson did not bill for any kind of quote unquote flurry of activity. She only billed for drafting 3 3/4 pages of text and claimed that 3 3/4 pages of text took 7.2 hours to write. That is not believable, respectfully. Further, on January 20th and 22nd of 2018, Ms. Peterson billed approximately 13 hours for drafting and filing a 2-page motion to strike. And that's on, you can find that on page, in Exhibit 3, if you have the exhibits, in transcript page 198. Appellee argues more was involved in her entries than drafting and filing the 2-page motion to strike, including, as she said here today, the 203-page brief, etc., and performed research. These are not the tasks that were billed again. How many data entry errors or I'm not good with dates excuses will this court tolerate? How many inaccuracies in dates, duplicative entries, suspicious amounts of time billed for simple tasks, block billing, and vague entries is this court going to allow before beginning to question the entire billing? Neither appellant nor this court can only assume that there were only data entry errors as to dates, rather than time spent on these activities or the very alleged activities performed that were in these statements for services. An appellant respectfully requests this court reverse the trial court's decision. Thank you.
Thank you. Thanks to both counsel for your presentation. Your case has now been submitted to this court. You will receive our opinion within a reasonable period of time. If there's nothing further, then Mr. Clerk, will you count the recess court?
This honorable court is adjourned for today.
Thank you. Attorneys may be excused.